Hello to everyone watching. My name is Patricia Bell, and I'm the Outreach Coordinator here at the Housing Equality Center of Pennsylvania. In this presentation, we will discuss the Fair Housing Act. By the end of this presentation, we hope you will have a general overview of the Fair Housing Act, be able to better identify housing discrimination, and know how to enforce your rights under the Fair Housing Act. The Housing Equality Center of Pennsylvania is the oldest fair housing council in the nation. Our goal is to educate the community about their fair housing rights and help individuals and families who have experienced housing discrimination. We serve the counties of Bucks, Chester, Delaware, Lehigh, Montgomery, Northampton, and Philadelphia. And we provide technical assistance and educational programs to support housing professionals throughout the Commonwealth. The rights and responsibilities of both landlords and tenants are regulated by fair housing laws and Pennsylvania's landlord-tenant law. Fair housing laws protect the right to live in the home of one's choice without discrimination based on race, disability, or other protected classes. And we'll talk about those protected classes in the next slide. Landlord-tenant laws govern the rights and responsibilities that both landlords and tenants have with regard to a rental transaction. This presentation will provide a general overview of fair housing law. This video is intended to provide general information about your rights under the Fair Housing Act and is not intended to provide any legal advice. The employees of the Housing Equality Center of Pennsylvania are not attorneys and therefore cannot render any legal advice. So let's begin by talking about the Fair Housing Act. The Federal Fair Housing Act stands as a testament to the legacy and great sacrifice of many civil rights activists. It was signed into law on April 11th of 1968. And this is a significant date because it was 7 days after the assassination of Dr. Martin Luther King Jr. The Federal Fair Housing Act makes it illegal to discriminate based on 7 federally protected classes. These classes include race, color, religion, national origin, sex, disability, and familial status. A good way to think about the protected classes is to think about the characteristics that are a part of our identities. Our race, the color of our skin, where we were born, or what we believe. The Fair Housing Act makes it illegal to discriminate against these 7 markers of an individual's identity. Those 7 protected classes are very important to remember because discrimination can take many forms and look very different just within those protected classes. Discrimination can be the refusal to rent or sell housing, refusing to negotiate for housing, making housing unavailable, or denying that housing is available. Remember that these discriminatory behaviors are connected to the protected classes that we talked about. So for example, setting different terms or conditions on housing because someone has a disability or because someone has children in their home would violate the Fair Housing Act. Advertising in a discriminatory manner is illegal, and threatening, coercing, or intimidating anyone exercising their fair housing rights is also illegal. I put a lot of emphasis on the 7 federally protected classes, but states and municipalities have the ability to create additional protected classes. So for example, Pennsylvania has 2 additional protected classes. They include age, so it's illegal to discriminate against people over 40 because of their age. And it is also illegal to discriminate against users, handlers, or trainers of assistance animals. Municipalities also have the ability to add additional protected classes. And there are about 70 municipalities in Pennsylvania with additional protected classes. For example, the city of Philadelphia has 15 protected classes. These protected classes are so important to become familiar with because discrimination is illegal on the basis of these classes. So when you are alleging discrimination, it is important to clearly state on which basis the discrimination occurred. We have discussed discussed many of the wonderful protections the Fair Housing Act provides individuals in the United States. But I want to spend some time talking about the limitations of the Fair Housing Act. The first being that the Fair Housing Act does not guarantee any person a right to housing they cannot afford. The Fair Housing Act cannot guarantee housing because the individual must be otherwise qualified. And housing providers are also able to set their rents to whatever the market will bear. And the agent or property owner may refuse to rent to a person if they have reliable information that the person has a recent history of violent, disruptive, or destructive behavior. The key word here being reliable. The landlord cannot deny someone housing because they have prejudicial beliefs that a person might be disruptive. Agents and property owners can adopt and apply uniform, objective, and non-discriminatory qualification criteria designed to evaluate a prospective tenant or buyer's creditworthiness, income level, or criminal history. The key words here being uniform and objective. A property manager could not, for example, require background checks for Black applicants and not white, or conduct credit checks for single mothers and not other applicants. The Fair Housing Act does not protect current users or dealers of illegal drugs. And while landlords are not required to rent to those who are currently using illegal substances, they cannot discriminate against individuals who have successfully completed a treatment program and are recovering from substance abuse addiction. Landlords may choose whether or not to participate in the Housing Choice Voucher Program as long as source of income is not protected under local law. So for example, the city of Philadelphia does have source of income protection. So landlords are not permitted to discriminate or deny housing to individuals using rental assistance in the city of Philadelphia. I want to take some time to discuss a few of the protected classes because again, discrimination can take many forms. Discrimination based on sex is prohibited by the Fair Housing Act, and I want to talk a little bit about what that might look like in practice. So rules that prohibit boys and girls from sharing a sleeping area are not permissible because that's not for the landlord to dictate to the tenant. And sexual harassment is also illegal. Housing providers requesting sexual favors in exchange for housing or making repairs is a violation under the Fair Housing Act. Sexual harassment includes harassment from landlords, property managers, maintenance staff, or any other employee. If a tenant is being harassed by another tenant and informs management, then management has a responsibility to address the harassment. Sexual orientation and gender identity are also covered under sex discrimination. Housing providers may not deny housing to anyone due to their gender identity or sexual orientation. Like I said in the beginning, discrimination can take many forms. The Fair Housing Act makes it illegal to discriminate against someone due to a history of experiencing domestic violence. Refusing to rent to someone because they have been a victim of domestic violence violates the Fair Housing Act. And domestic and sexual violence status is also an explicit protected class in the city of Philadelphia. We talked about the protected class of familial status in the beginning of the presentation. This protection makes it illegal to discriminate against families with children under 18, individuals who are pregnant, or anyone adopting or securing legal custody of a child. Senior housing is exempt from this rule under the Housing for Older Persons Act. But the HOPA program has very clear and strict regulations that the housing provider must adhere to in order to be considered housing for seniors. And we know that segregation is a form of discrimination, and segregating housing so that families with children are only permitted in certain buildings or on certain floors is illegal. So for example, a housing provider might say that they like to keep families with children on the first floor because they believe that children make too much noise, or that families with children would be happier closer to the playground in the back. But steering families to certain areas of a complex is discriminatory, and the housing provider has a responsibility to inform applicants about all the units available. Rules restricting children because of unsafe conditions, such as busy streets or balconies, are illegal. And rules that prohibit parents and children or boys and girls from sharing a bedroom are also discriminatory. Additionally, a housing provider cannot charge a higher rent or security deposit to families with children. The Fair Housing Act prohibits housing providers from discriminating against people because of where they were born or because of where their ancestors were born. This means housing providers cannot discriminate against someone because of their cultural or ethnic background or because of their language. And immigration status does not affect fair housing rights. Housing discrimination based on any protected class is illegal regardless of the victim's immigration status. This means individuals who are undocumented or underdocumented have rights under the Fair Housing Act and the ability to enforce those rights. And it is illegal to coerce, intimidate, threaten, or interfere with a person's exercise of rights protected by the Fair Housing Act. This includes threats to report a person to ICE if they report housing discrimination to HUD. Retaliation under the Fair Housing Act is illegal. Housing providers are allowed to request identity documentation and conduct inquiries to determine whether a potential resident meets the criteria for occupancy, so long as the same procedures are applied to all potential residents. I want to shift gears and spend some time talking about the protected class of disability. Disability is the protected class that has the most allegations of discrimination that occur throughout the country. The definition of disability under the Fair Housing Act is broad and is not the same definition or standard used to determine if a person qualifies for disability benefits. Disability under the Fair Housing Act is defined as a physical or mental impairment that substantially limits one or more of a person's major life activities. Disabilities can include mental or emotional illnesses, difficulties associated with aging, or individuals recovering from alcohol or drug addiction. And this definition also includes people having a history of an impairment. The Fair Housing Act also covers individuals that may not have a disability, but are perceived as having a disability. So, for example, while working as a housing case manager, I helped people who were experiencing homelessness find housing. This meant that I would often call housing providers looking for housing on my client's behalf or accompany my clients to appointments. I worked with people who had mental illnesses and people who did not. But there were times when landlords would perceive my clients as having a mental illness because I was working with them. Housing providers would make comments like, are they okay to live on their own? Or I don't want to rent to anyone that needs assistance. And now, to be clear, these statements would be discriminatory no matter if my client had a disability or not. But I want to emphasize that my clients who did not have a disability, but were perceived as having a disability and denied housing as a result, would also be able to file a complaint under the Fair Housing Act. Individuals with disabilities have the right to use and enjoy their dwelling on an equal basis, and reasonable accommodations and modifications can help do that. A reasonable accommodation is a change in rules, policies, practices, or services that enables a person with a disability equal opportunity to use and enjoy a dwelling. Here we have some examples of reasonable accommodations a tenant can request, and these include having an assistance animal in the home with no additional fees, a lease application in larger print, permitting a living care attendant, transferring to a more accessible unit or community, or a reserved marked handicap parking space. Reasonable modifications differ from reasonable accommodations because a reasonable modification is a change in the physical structure of a dwelling that enables a person with a disability equal opportunity to use and enjoy that dwelling. Some examples of reasonable modifications include the widening of doorways in the unit, the installation of grab bars in the bathroom or at the entrance of the unit, the removal of below countertop cabinets, the installation of wheelchair ramp at the entrance to the building or the unit, the installation of a fence or an awning, replacing door handles with levers, or the installation of visual and tactile alert devices. And typically the tenant pays the cost of the modification, but the landlord must allow the modification. However, if the housing is subsidized, the provider may be required to pay for the modification. A common reasonable accommodation request is to permit the use of assistance animals in the unit. Assistance animals come in many species, breeds, and sizes. When it comes to assistance animals, housing providers cannot refuse to allow someone with a disability the right to an assistance animal when the request is reasonable. The housing provider cannot deny occupancy or evict a person with a disability because they request an assistance animal. Before bringing assistance animals into the property with a no pets policy, a tenant should ask for reasonable accommodation from the landlord. Assistance animals are exempt from pet fees and pet deposits. Even if a housing provider has a no pet policy and agrees to allow the assistance animal in the home, they cannot charge extra fees or deposits for granting the accommodation. Housing providers cannot delay in responding to a request. This means they cannot blatantly ignore a request or require someone to complete burdensome tasks before granting the request. And additionally, housing providers cannot require an assistance animal to have any training or certification. If your disability is not obvious or the need for the assistance animal is not clear, the landlord can request that you provide a letter from a medical professional who's qualified to verify your disability and your disability-related need for an assistance animal. So the next big question is, how should reasonable accommodations and modification requests be made? And so please note that it is the responsibility of the person with the disability to make the request. It's not the responsibility of a housing provider to offer or suggest an accommodation or modification to a resident or prospective resident, even if they are aware of the disability or disability-related need. So it's very important for the resident to communicate the request to the housing provider. Requests can be made verbally, but it's best to make requests in writing via email or in a letter so that you have a record of the request. The request can be made by someone on behalf of a person with a disability, but it is crucial that there is a connection between the disability and the need for the accommodation or modification. And a person can ask for a reasonable accommodation at any time. This includes when they're applying for housing, when they're moving in or out, while living in the unit, or even during an eviction hearing in court. This is because people may require different accommodations and modifications at different times. In the unfortunate event you or someone you know experiences housing discrimination, it is important to maintain all records and documentation with names, dates, and details regarding the incident to help prove your case. It is helpful to write a narrative account and timeline of the incident as soon as possible when it's fresh in your mind. You can also file a complaint of discrimination with the Department of Housing and Urban Development by calling their hotline at 1-800-669-9777 or by visiting hud.gov, but the complaint must be filed within the year. Or you can file the complaint with the Pennsylvania Human Relations Commission by calling 215-560-2496 or by visiting their website at www.phrc.pa.gov. But complaints must be filed within 180 days of the incident. You also have the option to file a lawsuit within 2 years from the incident. And the Housing Equality Center is here as a resource to speak with you about your enforcement options and where to file your complaint. Because again, if you live in the Philadelphia, Bucks, Chester, Delaware, Lehigh, Montgomery, or Northampton counties, you can call Housing Equality Center of Pennsylvania. We are here as a resource to offer counseling, investigation, and educational services. You can call us at 267-419-8918 or email us at info@equalhousing.org. You can also check out our website, equalhousing.org, where you can sign up for fair housing news, register for an upcoming fair housing event, learn about fair housing laws, and so much more. On our website, you can also download guides, resources, fact sheets, and fair housing guidance. You can also check out renters.equalhousing.org for information and resources for renters in Pennsylvania. We also have some customizable letters for you to download for a variety of situations. And of course, you can always follow us on Facebook to stay up to date on events and activities. Thank you for watching, and we hope to see you at our next fair housing event.